Good afternoon, everybody. Alrighty, so you got an email from me about this, but just a reminder that you can participate in studies for extra credit. So if you have a SONA account from previous semesters, you can just log on with that. If you need to set one up, the process is pretty quick. So you just set up for it, and then Dr. Ariel will approve you and you'll be good to go. And this is also like, please help your fellow students out, because also these are students who are conducting the projects, doing the 480 class. So little plug there. So today we're going to finish talking about jury selection, and then we'll start talking about jury deliberations. And then Tuesday, we will watch 12 Angry Men and look into jury deliberations there. So we're getting close to the end of the semester, which is sort of mind-boggling, but in about a month we'll be finishing up. So alrighty, I'm going to go ahead and share screen. Okay, and pick this up where we left off. For some reason it's not. There we go. They just changed the menu since Tuesday. Just want my captions on. How about that? Huh. Give me just a sec. This is weird. It usually gives me a little menu where I can just turn on the captions. It's not doing that, so give me just a sec and I'm going to Google and see if they changed that. Yeah, that's from 2018, so that's not going to help. Okay. Well, I'm going to go without them, and I apologize to anyone that they usually help with. I'm not really sure, again, what changed between now and Tuesday. But I will post this to YouTube like I typically do, and then that will add captions later. So that's super weird technology, right? It's so helpful, except when it's not. Okay. So we had just been talking about jury selection and how traditional jury selection, we don't actually predict better than chance whether someone's going to side with this particular side or not. So we're going to talk about scientific jury selection, which is a big part of how psychologists can help with jury selection. So in this case, a psychologist or other social scientist will help lawyers identify jurors that will help their cases. And Consultation is much more often for the defense than for the prosecution in criminal cases, often because the prosecutor's office doesn't necessarily have a ton of money laying around, right? And in terms of methods here, we might do community surveys where we look at how persuasive the arguments that this lawyer is planning to make would be, and how persuasive would the evidence they're planning to present be. You can also ask about perceptions of the case characteristics, perceptions of the litigants, those involved in it, trial-related issues. You can get background on who those people are and, you know, sort of who you should expect to be on the jury. And then you can develop demographically based profiles of individuals who are most or least responsive to care themselves, or to the case themselves and the case themes. So pre-trial surveys, so one thing backing up, community surveys would just be people in the community. Maybe you do like a random selection from the phone book that still exists, believe it or not. But it would just be people in general who live in that area. Pre-trial surveys would be the people who are actually summoned to the courthouse to be part of the juror pool. Okay. And here you would not include questions regarding evidence persuasiveness because you don't want to like tip your hat, basically, right? You can also do mock juries where you would have a group of people come in and pretend to be the jury and examine how different types of individuals respond to different trial strategies and approaches to information and how you're going to present it. So you might give several different variations on your opening arguments or your closing arguments and see how they respond. It's kind of like a focus group, but more structured. But you can do a focus group where you would just have the people like come into a conference room and give you similar feedback. With mock juries, you would sort of set up a fake courtroom situation to sort of replicate all of that. Many jury consultants provide services in realms other than jury selection as well. For example, consultants conduct public opinion surveys, focus groups, and mock trials. They would analyze how different jurors form a narrative that summarizes the evidence. And this allows consultants to derive central themes, which can be used to organize the evidence to support the attorney's desired interpretation of the facts. There is a lot more research needed on scientific jury selection. So it depends on the case itself to a large extent, how helpful this actually is. The effectiveness of scientific jury selection depends on another number of variables, including how many challenges are allowed, the extent to which questions delve into matters beyond superficial demographic details of prospective panel members, whether attorneys actually do what the consultants tell them to do, right? You can give all the consultation in the world, but if the attorneys ignore your advice, you're not going to be that effective. And perhaps most importantly, the extent to which jurors' attitudes and beliefs will determine the outcome of the case. Interestingly, we tend to see that scientific jury selection works the best in drug-related cases and then in military court-martial cases. But again, it's still growing. So there are a couple different methodologies here. One is to look at the demographic characteristics of the jury, like, is it representative of the community as a whole? And then also looking at juror characteristics related to the outcome, again, that the attorneys want. So you need to actually relate those characteristics to the potential outcome. You can ask the person how they would vote if they were on a jury in a community survey, for example. But the problem is they're often doing that like from the comfort of their home, right? And they might actually act and decide differently were they really on a jury, right? It's a very different situation. You're surrounded by other people who are also trying to make the same decision. And also they haven't heard all the evidence during a community survey, right? To fix it, you try to present facts as in an unbiased way during a phone survey or mock trial. And what they found based on this so far is that demographics are really limited and have a weak relationship to decisions and maybe case specific. They can be helpful in federal cases where you don't have much else to go on. What we find is that people who are richer, higher socioeconomic status, are more likely to convict. As we talked about last time, it depends on the case, whether people of the same race are going to be sympathetic, or particularly if you're the same race, but you're a higher socioeconomic status than the defendant, you may be more likely to convict because that person, again, is reflecting poorly on your community, that black sheep perspective we talked about last time. In general, for some reason, Black individuals seem to support not guilty by reason of insanity pleas more often. In terms of gender and cases related to women and kids, women tend to rule in favor of the woman more often. So they're more likely to convict offenders who are rapists, child sexual abusers, sexual harassers, for example. And they're more likely to acquit battered women who killed their husbands. In terms of personality characteristics, one that's been looked at is authoritarianism. What happens in authoritarianism is that anyone who's perceived as having less authority than you is judged very, very harshly. So if you're high on authoritarianism, anyone who's got less authority than you is held to this really high standard. However, those who you perceive as having higher authority than you are admired and given a lot of leniency. So higher levels of authoritarianism predict conviction and harsher sentences. And I think part of what might happen here is that because they hold those in higher authority in esteem, they might be trying to please the judge, influenced by the judge's nonverbals. Another personality trait they found is related here is locus of control. So people who have an internal locus of control believe that you are responsible for what happens to you. And if you have an internal locus of control, you're more likely to believe others are responsible for their own actions, right? So then you would judge more harshly. So in 2011, Liberman published this great review article on scientific jury selection called Still Murky After 30 Years, and it kind of summarizes a lot of this. So one of the things he points out is that attorneys use trial consultants for almost all major litigation. Is it effective? Well, the consultants themselves are going to report really high success rates, right? Because they want you to hire them. They want you to pay the big bucks. It costs quite a bit to hire a consultant. So it's typically consultants are used where premier attorneys are also used, right? Because they're either going to include that in their fee or have clients who can't afford to shell out for this. So it's unclear if it is the consultant who is the reason for success, or if it's just you have a better attorney, right? Or at least one who's better known. Demographic factors here tend to account for less than 2% of the verdict variance when examined, so not very much at all. And that 2% is when each demographic characteristic is examined independently. And if you put a bunch of demographic variables together, it's still less than 5% of the variance in the verdict. So demographic characteristics really aren't telling us that much about how a jury will decide. They're inconsistent, they're context dependent. Again, for example, gender in general is unreliable, but it's clearer in sexual assault cases. There's an argument that there might be like a legal personality or legal attitudes, and that might have greater predictive accuracy when specific measures of legal attitudes relevant to trials at hand are used. So for example, they might ask, what are your attitudes towards mental health professionals in insanity cases, right? And things like that will give you much more specifics. Even if we combine all these other factors, what we can predict remains fairly low. So there's very little research actually examining the effectiveness of scientific jury selection. And research out there says it's great. It's over 70% accurate, but it's really unclear how credible that is. It's often highly artificial, so they're doing mock trials, for example, or they're not directly comparing people who have used SJS and people who have used traditional methods. So scientific jury selection may be most beneficial when evidence is equivocal and a slight advantage, again, this 2 to 5% advantage, might impact the outcome of the case. So if there's a case where the evidence is pretty clear, pretty cut and dry, this is not going to be that helpful. Evidence strength is a much better predictor of jury verdicts than are juror characteristics. So juror characteristics, again, remember 2 to 5% of the variance. Evidence strength is about a third, 34% of the variance in verdict. So the case where the evidence is really strong, again, scientific jury selection should be a weak influence. But these cases actually rarely go to trial. So these folks will do a plea bargain and never go to a full court case. So the evidence is, if the evidence is relatively balanced, then small increases in predictive ability gained from scientific jury selection may actually be highly advantageous. So that's where psychologists doing this research can actually be really helpful. All right, so what are some of the ethical issues in jury selection? Well, critics have condemned the whole idea of jury selection as jury rigging, techniques that undermine public confidence in the jury system and give wealthy litigants an unfair advantage over poor or average income citizens. You could see how they could argue that, right? However, many believe that because litigants are expected to present their version of the case as zealously as possible, they should be able to use every legal means available to sway the jury to reach a favorable decision. So again, controversial. All right, so what about how judges decide versus how juries decide? Defendants in criminal trials ordinarily have a jury trial, but if the prosecutor consents, they can choose to have a judge decide, and that's called a bench trial, where the judge decides and there's no jury. Citizens tend to believe that a jury decision offers more procedural fairness, greater thoroughness, better representation of the community, fewer personal biases affecting decisions than a decision by a judge. That is the commonly held belief. Do juries and judges generally agree with one another? So Calvin and Cecil, back in 1966, asked judges questions about recent jury trial. So like, what was the verdict from the jury trial and did the judge agree? In criminal and civil trials, the judges reported that their verdict would have been the same as the jury's actual verdict in about 75%, 3/4 of the cases. In only 19.5% of the criminal cases did the jury return a guilty verdict where the judge would have ruled not guilty, or the jury returned an innocent victim where the judge would have ruled guilty. In most of the discrepant decisions, the jury was more lenient than was the judge. So what are the determinants of these discrepancies? Well, a few of the discrepancies apparently resulted from facts that one party knew, but the others didn't. So in some trials, the jury was swayed by the apparent superiority of one lawyer as well. And about half the disagreements involved jury sentiment, so feelings expressed by the judge. So the jury verdict was determined by factors beyond the evidence of the law, so that the jury itself might have had bias. However, there has been a critique of the Kelvin and Ziesel study. So judges were permitted to choose which trial or trials they reported. They sent the invitation to participate to 3,500 judges, and only 555 participated. So there may be something in there that skews this, right? The juries have changed in many ways since the study was conducted. Our juries are much more diverse in terms of gender, ethnicity, race since then. And we only have the judge's attribution of the jurors' feelings and sentiments. We don't actually know if that's what the juries were thinking, right? So there are some new data on judge and jury differences. And this is from researchers at the National Center for State Courts. And they collected data from jurors, judges, and attorneys in more than 350 trials, and this was published in 2005. And the rate of jury-judge agreement was 70%, and when there was disagreement, juries were more lenient. So again, very similar to Kelvin and Ziesel. Jurors do tend to be more lenient with judges when it comes to determining guilt, but they can be harsh when it comes to sentencing decisions. Why are the jurors more harsh when it comes to sentencing? Well, one explanation is that jury trials are very expensive, and judges want to encourage defendants to plead guilty and avoid those costs. Thus, judges may deliberately choose more sentences as an incentive to encourage that plea bargaining. So in 2002, data was analyzed from nearly 9,000 civil trials, and the primary finding was that judges and juries did not differ substantially in these cases. They awarded punitive damages of about the same size, but the range of the jury awards was somewhat greater than that of what the judges. So they were going lower and higher, but if you averaged it out, it was about the same. Now, in terms of the psychology of trial judging, this is from Vidmar in 2011. Judgments are subject to influence by the judge's personality, attitudes, past experiences, etc. And we look at training and legal precedents. So lawyers are taught to look at the facts and reason by analogy. They apply facts and they place things in categories, kind of similar to scientific disciplines. And judges almost all the time begin as lawyers. So this is the training that they have. However, legal decision-making also has a heavy deference to precedent. So if you stray too far from legal precedent, what's been decided in previous cases, a lot of times the case will be appealed and then the ruling overturned. Another issue is that judges are dependent on the evidence presented. That really affects their ability to make an accurate decision. In some European countries, as we mentioned way at the beginning of the semester, the judge themselves has investigative powers, where the judge themselves could actually ask questions, for example. Another problem is that judges' work is embedded in bureaucracy, right? Just like a lot of things. So there's constraints because of what they're allowed to do. Legal training does not seem to insulate judges from common cognitive errors. For example, one study, they presented judges with inadmissible evidence and told them they should disregard it. And despite their legal training, the judges were really similar to lay people in that they could not disregard the impermissible facts once they heard them. And again, this is why attorneys will often introduce stuff that they know is going to be objected to, because once the jury or the judge hears about it, they have a really hard time putting it out of their mind. Also, sentencing discrepancies. There are disparities based on race, ethnicity, and gender. We tend to see longer sentences for Hispanics and African Americans. Some studies suggest these may be influenced by courtroom behaviors. There's also disparity in probation officers and the quality of the legal representation they get, which is surely part of this as well. Alrighty. So that is the end of the jury selection. And the next thing we're going to talk about is jury deliberation. Whoa. We got way zoomed in. Oh, I see. It just doesn't fit the screen. Cool. That's all right. So it looks like there's now a shortcut on the captions. Control-Shift-C. Let's see. Now if I talk, are there captions? Yes. Okay, sweet. I figured it out. That took way too long. All right. All right, so now we're going to talk about the jury has already been decided on, and they are hearing the case, and then they have to make a decision based on their deliberations. So most legal disputes are resolved without a jury trial, but there are still more than 150,000 jury trials conducted in the US each year. Approximately 2/3 of Americans have been called to jury duty, and approximately 1/4 have actually served as jurors. Juries have often been criticized. So for example, some people argue that civil juries award excessive amounts of money. But juries also have their defenders. So verdicts reached by representative juries can and often do increase the legitimacy of the process in the eyes of the public, particularly in controversial trials. So a big question that has been raised repeatedly is, are juries competent to make these decisions? They are not trained, right, specifically in this. They might get brief training from the judge or instructions. But psychologists have examined factors that affect the accuracy of jury verdicts. So we have learned that evidentiary strength is probably the most important determinant of jurors' verdicts in both civic and criminal trials. But jury decisions can also be influenced by extra legal information. So irrelevant information about the defendant's background or appearance. And this is exactly what they're trying to do in the Derek Chauvin trial, for example. They're basically trying to put George Floyd on trial when he is not, right? Why are jury decisions influenced by irrelevant information, right? Like it shouldn't happen. Well, back to good old Calvin and Cecil, who we just talked about. They came up with what they called the liberation hypothesis. And they said when the evidence in a case clearly favors one side, juries will decide the case in favor of that side. Like, okay, this is what the evidence says, that's what we're going to decide. But when the evidence is ambiguous, jurors are liberated and allowed to rely on their assumptions, sentiments, and biases, that extra legal information in reaching a verdict. So the effects of extra legal information are something that's really important to consider. The mechanism by which juries reach these decisions is called the dual process theory of attitude change. And Eagley and Chaikin came up with this term in 1993. And that distinguishes two different kinds of information processing strategies or routes. So there's central, which focuses on evidence. But when the evidence is confusing, people will look at more of a peripheral or use a peripheral information processing strategy. And that focuses more on the extraneous details. So once jurors have heard evidence about a defendant's prior criminal record, they may be prejudiced by it and judge the current offense in light of those past misdeeds. So the prosecution is often not permitted to introduce this evidence for that reason. But if defendants take the witness stand, then prosecutors may be able to question them about certain types of past convictions in order to impeach their credibility as witnesses. If the defendant takes the witness stand, the judge may choose to issue a limiting instruction, for example, saying that evidence of a defendant's prior record can be used to gauge the defendant's credibility, but not to prove the defendant's propensity to commit the current charged offense. Limiting instructions are, maybe not surprisingly, rarely effective. Thus, attorneys often recommend that clients with prior records not actually take the witness stand to testify on their own behalf. Mock jurors informed of a defendant's prior conviction were more likely than jurors with no information about a prior record to convict the defendant on the subsequent charges, even if the similarity of charges, although similarity of charges itself is an important variable. So like if the prior conviction was like petty theft and this is murder, maybe not. But if there was like a prior murder charge and this person's up for murder, it would affect it. So most courts permit criminal defendants to be tried for 2 or more charges at the same time, as long as the offenses are similar and connected to the same act. This is looking at evidence on multiple charges, and it's technically called a joinder. Researchers have found that defendants are more likely to be convicted of any single charge when it is tried in combination with other charges than when it's tried alone. So there's some advantage here for the prosecution. Historically, evidence about the defendant's character and propensity evidence of other wrongdoing, could not be used in court. Sex crimes, however, are treated differently in federal courts and in some states. So evidence of other sex offenses is admissible to show a defendant's propensity to commit the charged sex offense, because we know that a vast majority of sex offenders are serial sex offenders. So what effect might propensity evidence have on jurors? Jurors likely will tend to make the fundamental attribution error, right? Oh, well, if he's had a previous conviction on this, or she has, then this is just something wrong with this person. Okay, so that was criminal cases. What about in civil cases? How does this extra legal information come in to play there? Well, juries in civil cases typically make 2 fundamental decisions. The first is liability. So is the defendant, or in some instances the plaintiff, liable or responsible for the alleged harm? And the second decision they make is whether the injured party, typically the plaintiff, should receive any money to compensate for his or her losses, and if so, in what amount? And these monies are called damages. So in terms of determining liability, when psychologists study juries' liability judgments, they are really asking how people assign responsibility for an injury. Like, how do you decide who is responsible for this? Jurors should decide liability on the basis of the defendant's conduct. The severity of an injury or accident is irrelevant to a judgment concerning liability or legal responsibility. But do jurors always determine liability correctly? Not necessarily. So why would we assign more responsibility to an individual as the consequences of his or her or their own conduct become more serious? So a possible theoretical explanation is defensive attribution, and Fisk and Taylor came up with this in '91. So as the consequences of one's actions become more severe, we're more likely to blame the person for their occurrence, because doing so makes the incident somehow more controllable and avoidable. So the idea here is if we can say this horrible, horrible thing happened and it's this particular person's fault, then we can almost self-protect and be like, well, I don't know any people like that person, so this is never going to happen to me. In terms of assessing damages, in state court civil trials in 2005, the median damage award was $28,000, and only 4% of winning plaintiffs received more than $1 million. So I think we have this idea in our head because the cases we hear about are like the McDonald's burning coffee case, right? That somehow everybody gets multi-million-dollar damages, but that is not the case. In general, the more a plaintiff requests, the more a plaintiff receives. Juries tend to adjust their awards towards anchor points, and the most obvious of which is the plaintiff's requested damages. And so this is why typically people will sue for sort of astronomical amounts, because the idea is if the juries adjust it downward, they're adjusting it downward from this high amount, and so it'll still be a good amount they get in the end. So what factors do juries consider in weighing their decisions about damages? As in criminal cases, jurors put the most weight on the evidence they hear in court. But sometimes they consider attorney's fees and whether any loss is covered by insurance, issues that are theoretically irrelevant to decisions about the amount of damages to award. Most of the evidence indicates that a judge's admonition to disregard inadmissible evidence is relatively ineffective. And again, this shouldn't surprise us, since we just talked about the study that showed even judges don't ignore inadmissible evidence, right? So note, jurors are more likely to comply when a judge's instruction to ignore inadmissible evidence comes with a reason. So if the judge explains why they should ignore it, juries are more likely to comply with ignoring it. Instructions to ignore inadmissible evidence can backfire and result in juries being more likely to use the inadmissible evidence because attention has been drawn to it. Jury deliberations can lessen the impact of inadmissible evidence as well. So what about expert testimony? We've spent all this time so far in the semester talking about, can psychologists be expert witnesses? What effect does this have? So experts here typically testify about scientific, technical, or other specialized knowledge. And particularly, experts are allowed when most jurors would not be familiar with that information. There are some concerns here. Because jurors lack rigorous analytical skills, they may use peripheral processing, so attention to superficial aspects of the expert's testimony. However, that concern has not been supported by evidence in studies that have looked at how people react to expert testimony. Other people worry that expert testimony will mesmerize jurors, causing them to discount their own common sense and rely too heavily on the expert of the opinions. So going back to Tuesday, this is like the razzle-dazzle argument, right? This is the, it's a spectacle. This person is held in high esteem, so we're just going to listen to whatever they say. Evidence does suggest that when prosecutors introduce expert testimony, convictions are more likely. When experts testify on behalf of the defense, the likelihood of conviction decreases. Now, obviously, though, this will wash out if they each have their own experts, right? Research suggests that jurors do not routinely defer to the expert's assessment. Judges who ultimately decide which expert evidence is admitted into court, as we talked about earlier in the semester, the Daubert versus Meridol Pharmaceuticals case in '93, judges may allow unreliable expert testimony to be admitted into evidence if it's not presented as such, right? If they can be convinced that this person is reliable. Are jurors able to distinguish between reliable scientific evidence and junk science? In general, no. In general, jurors are not able to distinguish valid from flawed research. And this should really not surprise us, given a lot of the things that have happened in the past year, right? Like people refusing mask mandates, people having very strange ideas about vaccine science, right? People not believing that COVID is even a thing, right? So those are members of the general public. So why on earth should we expect juries to suddenly like magically be able to understand things, right? So it's important to note that they can be swayed in either direction. Okay, now another thing is, can juries understand their instructions? The greatest weakness for many juries is their inability to understand their instructions. In fact, the instructions are often full of legal terms that are unfamiliar to lay people, sort of jargony, right? The jurors may or may not be provided with a written copy of the instructions, and they're almost never allowed to ask questions in the courtroom to clarify any misunderstandings they have about the law. Psychologists have been able to simplify jury instructions, and those simplified instructions have been shown to be easier to understand by jurors. Although those in the legal system have not generally been receptive to reform suggested by social scientists, some have recently revised portions of their jury instructions. So for example, the state of California really listened to social scientists here. Although instructions are typically read just before the jury retires to deliberate, some states now require judges to provide preliminary instructions before the trial begins, or at least before the evidence is presented. Instructing juries at the conclusion of the trial reflects a belief in what's called the recency effect. So recent events are generally remembered better than remote ones. The idea that jurors should be instructed before presentation of testimony because it gives them a mental framework to appreciate the relevance or irrelevance of testimony as it unfolds basically rests on the notion of the primacy effect, or the idea that things that are presented first are most retained, and the instructions will have their most beneficial effect if they're presented first. Now, both the primacy and recency effects are things. There have been lots of scientific psychological research that shows that both of these effects do in fact exist. And even in something as simple as like remembering a list of words, for example, you're most likely to remember like things at the beginning and things at the end and kind of forget the stuff in the middle. Forster, Lee, and Horowitz in 2003 reported that mock jurors who received instructions at the start of the trial recalled and used more evidence than did jurors who were instructed after the evidence. So there is some suggestion that giving them before might be really helpful. Jurors who received pretrial instructions said they were able to focus better during the trial. They sort of knew more what they should be focusing on and looking at. And judges also believe that substantive preliminary instructions help jurors to follow the evidence. So my guess is this will really be the wave of the future, is that more and more jurisdictions will use preliminary instructions. Actually, before I go to that, one thing I should talk about really quickly is, okay, so you have the instructions, you understand them. How willing are you to apply them? That becomes important. So juries have the power to acquit defendants despite evidence and judicial instructions to the contrary, although they don't often know that they have this power. This power is just termed jury nullification, has permitted jurors to acquit defendants who were legally guilty but morally upright. So, for example, someone who killed someone in self-defense. What does the empirical evidence say about jury nullification? How would juries behave if they were informed they had the option to disregard the law? Another study by Horowitz and colleagues showed that jurors tend to rely on their feelings and sentiments and only nullify the law when that law seems unfair. All right, so what about deciding really complex cases? Complex civil cases in particular often require the jury to render decisions on causation, liability, and damages. And sometimes for multiple plaintiffs, multiple defendants, or both. So for example, like a class action lawsuit, right? There might be hundreds of people involved. In many criminal cases, The use of forensic evidence can contribute to case complexity. If we're talking about DNA analysis, things along those lines. So many arguments have been made against the use of juries in complex cases. People have argued the evidence is too difficult for a layperson to understand. People have argued the general information load on juries is excessive because of the large number of witnesses. And less capable jurors are left to decide due to voir dire because we have excused all the jurors familiar with the case, they're familiar with legal terminology. The complexity of a trial does impact jurors. Another Horowitz study back in '96 found that complex language lessened jurors' ability to compensate plaintiffs who suffered injuries of varying severity. So this really speaks to, if you're going to be an expert witness, if you're going to be an attorney in these cases, really making sure your language is clear and something that sort of the person with maybe like a high school education can understand. Overall, findings point to the need for attention to how a complex case is presented to the jury. So one suggestion has been giving jurors the opportunity to take notes, which is not always permitted. So all of this starts to boil down to, are juries biased, right? Is there just like a problem from the get-go here? Well, one thing that's been talked about is the blank slate assumption. Courts assume that jurors can put aside any preconceptions about defendant guilt or the merits of civil defendants and plaintiffs when forming judgments. Is a fair and unbiased jury an impossible ideal? I mean, as we've talked about with voir dire, attorneys are really motivated to select jurors who are favorable to their own side, and it's impossible for anyone to be completely uninfluenced by past experiences and resulting prejudices. Again, we try to sort of screen that out during voir dire, but there might be things we don't catch. So juror bias is a juror's predisposition to interpret and understand information based on past experience. And this is not something that like only bad jurors have. Anyone who's ever served on a jury has this, just based on your own experience. Personal predispositions may affect views toward either the prosecution or the defense and affect the way that the evidence is evaluated. Jurors may show pre-decisional distortion, distorting the evaluation of the evidence to support their verdict choice. And this is something that people in general do, right? So if we hear information we don't agree with, we tend to disregard it or poke holes in it, right? Whereas if we hear information that supports our opinion, then we are much more likely to accept it, even if it's not as strong. Do jurors' biases predispose them to favor one side over another in a civil case? Although elements of sympathy play some role in deliberations, as do feelings of anger toward a defendant, the general public has been found to be quite suspicious of and sometimes downright hostile to civil plaintiffs. This is the idea within our society that people just get fed up with people just suing everyone left and right, is the perception, right? And so that'll carry over into a jury. Do juries give larger awards when a defendant is wealthy? Jury damage awards are consistently higher in products liability and medical malpractice cases than they are, say, in automobile negligence cases. It appears that any inflation of awards against corporate defendants is apparently related to their status as a corporation and not necessarily to their wealth. So corporations are held to a higher standard of responsibility than are individuals. How do jurors make sense of the evidence that they hear during the trial? Jurors construct stories about the evidence so that it makes sense to them. And this is a totally normal, natural human thing to do. This is just a way that we help ourselves remember things, process things. In fact, one of the ways we look at memory in different ways is by having people learn lists of words versus learning a story. And in general, people remember more information from the story because this is sort of how we construct our lives, right? Like if you're telling someone about what happened today, it's going to be a story, right? It's not going to be a list of words, right? So this is just the way we think of things. So in that process, jurors may pay attention to certain pieces of evidence while ignoring others, just because, again, it fits into this narrative they're creating. Hastie and Pennington developed the story model to describe inferences that individual jurors make when reaching a decision in a case. Again, going along with creating this narrative. Okay, so if we know there are all these problems with using juries, what do we do? How do we fix it? So some reforms have been uncontroversial. Everyone's just like, yeah, this is good. So listing witnesses and summarizing their testimony in long and complex cases, giving pre-instructions or interim instructions during a lengthy trial, or maybe both, allowing jurors to take notes. I mean, that just seems easy, right? Another thing that people have started doing is to designate alternate jurors only after the trial so that the alternate jurors pay attention, right? Giving a written copy of the judge's instructions can be really helpful. And then allowing jurors to examine the demonstrative evidence during their deliberations. So when we watch 12 Angry Men, you'll actually see that. They like call for pieces of physical evidence to be brought into the room for them to examine. Two reforms have been seen as more radical. So one is allowing jurors to post questions to the witness. The questions would be screened by the judge, who would decide whether or not they are appropriate. And jurors questioned about the opportunity to submit written questions have been really supportive of that idea. The second one is allowing jurors to discuss the evidence in midst of the trial. So most judges tested indicated that they did support this. About half of the attorneys and litigants tested that thought that trial decisions improved juror understanding of the evidence, trial discussions, sorry. And although the other half agreed that the trial discussions might encourage premature decision making. So that's where the controversy comes in here. And jurors who reported having these discussions are really positive about them as a way to start looking at things. All right, so I got through that a little quicker than I thought. So to give us plenty of time for you all to discuss the film on Tuesday, I am going to see if I can get my DVD drive to talk to my computer, and we can start 12 Angry Men, and you can start to see some of this stuff in action. So for those of you who aren't familiar, this is really a classic film. It is in black and white. It is based on a play. So there are times where the blocking, sort of the stage directions for people is very obviously something that might be done on stage more than in real life. But it's a really great examination of what these sort of extra legal factors might look like as they are, as a jury deliberates. So I am going to stop screen sharing for a minute and see if my computer will talk to this DVD. It's always a challenge. Thing. We'll see what we get. All right. So I'm going to be right back because I'm going to have to restart my computer and then it will talk to it. So everybody just sort of hang tight and I'll be right back and we'll watch about 20 minutes of the film.